Today is December 1st, 2021. My name is Rob Carr of Kalamazoo Right to Life, and this is Pro-Life Week. Well, today was a historic, momentous day. This morning at 10 o'clock, the justices of the Supreme Court heard oral argument on Dobbs versus Jackson Women's Health Organization. That's the case that emanated from the state of Mississippi. The Gestational Age Act, passed in 2018, prohibited abortions after the 15th week of pregnancy. So we shall see how this all turns out, because the court will have a conference later on this week, and they will take a vote. And however way the vote goes, the Chief Justice will assign that case to one of the justices who's in the majority opinion to write the decision, to write the opinion. And we probably will not know what that is until June or July of next year. So we're going to be held in suspense for the next 6 months while they draft an opinion. But I only got a chance to hear most of the argument between the justices and the pro-abortion side. I was standing outside of Planned Parenthood praying during the first hour when the justices were talking to the Solicitor General from the state of Mississippi, who was presenting the pro-life side. So I never got a chance to hear his arguments, his positions, and his answers to their questions. But I did get a chance to hear some of the comments and answers by the pro-abortion people, and especially some of the questions that the justices asked the pro-abortion side. And so I just have a few comments. The first is Justice Clarence Thomas, who usually is very, very, very quiet in oral argument. He hardly ever asks a question. I think somebody said that he didn't ask one question in 10 years in oral argument. Well, today he was very verbal. He asked a lot of questions of both sides. And perhaps that's very telling, because he's invested in this issue, and he's one of the few justices who has come out on record as saying that he would vote to overturn Roe v. Wade, that it was wrong the day it was decided. It was egregiously wrong. So he was very involved in this case today. Two, Justice Brett Kavanaugh brought up a whole host of cases that the Supreme Court used to overturn previous cases. You know, the court has this thing called stare decisis, Latin for let the decision stand. The basis is it's a legal doctrine that the court is almost obligated to abide by previously decided cases when they're dealing with a new case with a similar issue. They always refer back to the previous decisions. And he brought up a whole host of cases where the court bypassed stare decisis and overturned them. And he's kind of asking, well, why not now? Why do we have to abide by Roe v. Wade and Planned Parenthood versus Casey, which is the big follow-up case to Roe v. Wade back in 1992? Why do we have to follow these? Why can't we review the whole issue and strike a new balance? So then he asked another set of questions dealing with, why can't the court be neutral on abortion? Not favoring the pro-life side, not favoring the pro-choice side, but allowing the people through their elected representatives to make policy decisions, abortion policy in each individual state. So Kavanaugh is asking, why can't we send this issue back to the states and let the states decide? And like here in Michigan, if Roe is overturned and is sent back to the states, on day one, Michigan becomes an abortion-free state, because we already have a law on the books that has never been rescinded, and the Michigan Supreme Court has actually upheld and said it is still the law of the state. Obviously unenforceable now because of Roe v. Wade, but passed in the law was passed in 1846 and reaffirmed in 1931, but it is the law in the books in Michigan. You cannot have an abortion throughout the entire 9 months of pregnancy. So in states like Michigan and maybe some other conservative red states throughout the country, abortions would be banned or severely restricted. But in places like New York, California, Massachusetts, Illinois, Vermont, we got Vermont, Washington, Oregon, liberal states where they've already got laws on the books protecting or codifying legal abortion, that abortion would be legal in those states. Now that's obviously not my solution, because you'd have like a patchwork of laws. You've got pro-life laws here and pro-abortion laws here. So that's not, to me, the optimum solution. But at least it's a whole lot better than what it is today. So that was one of Kavanaugh's arguments. Then Sam Alito asked a very interesting question of the pro-choice attorney who was representing Jackson Women's Health. And he said, or he asked, what was the name of the pro-choice scholar who heavily influenced the historical section of Justice Harry Blackmun's Roe v. Wade opinion? And she said that she could not think of his name. She can't pull his name out. And I'm thinking, you've got to be kidding. I know the guy's name. And I've known his name for 20 years. His name is Cyril Means. He was the lead counsel for the National Abortion Rights Action League. Well, actually, he was the lead counsel for the National Association for the Repeal of Abortion Laws. That is NARAL. That's the same organization that changed its name after Roe v. Wade to the National Abortion Action League, NARAL. So he was an ideologue. He was a zealot. He's a law professor in New York City, wrote two heavily influential articles, one in 1968 and one in 1971. One dealt with British common law, and the other dealt with the abortion laws in the state of New York from the time of the Revolution to the common day, the modern era. And he was cited 7 times by Justice Blackmun in the Roe v. Wade opinion. So heavily influential, and I was stunned that she could not pull his name out. I mean, he's one of the pinnacles. He's one of the pioneers of the movement, and she can't pull his name out? I mean, come on now. I personally think that was just a sleight of hand on her part. I think she chose to be ignorant, because had she pulled his name out, then perhaps Alito would have given a follow-up question, and then another follow-up question, and another one, because Sarah Means' scholarship has been debunked. His scholarship was built upon falsehoods, mistakes, lies, just distortions of the historical truth, and her hiding the fact that she did not know him perhaps saved her from embarrassment. So that was interesting. Number 5, several justices talked about the issue of the viability standard, which is at the heart of this whole issue. Can Mississippi pass a law banning abortion after 15 weeks when the viability standard is either at 24 weeks or at some other nebulous period? Originally with Roe, it was at 28 weeks. Then it was lowered to 24 weeks as medical technology improved. And now, what is viability today? 21, 20 weeks, 19 weeks? I mean, it's shifting sand. And should we be basing a constitutional right on an arbitrary medical decision or procedure that is not, it's not a firm foundation. It doesn't have a firm foundation. It's very shifty. It's like sand, shifting sand. And my last point is that Chief Justice John Roberts, even he came down kind of hard on the whole issue of fetal viability as well. So how is this all going to play out when they vote later on this week? No one really knows. But I am hopeful. Just by hearing some of the questions and some of their comments, that I am hopeful that the court is going to rule perhaps 5-4 or 6-3 in favor of the Mississippi law, that they're going to retain that law, which would jettison the whole issue of fetal viability. So I'm not sure what's going to happen after that, but they may say that states have the constitutional right to enact new legislation based on this new viability non-standard, because it won't be a standard anymore. So whether or not the court's going to overturn Roe v. Wade, I don't know. I do know some of the justices would be in favor of that. I think probably Barrett might, Kavanaugh, Alito, Clarence Thomas, those four I'm sure would probably vote to overturn Roe v. Wade entirely and throw it back to the states. I don't know about Gorsuch or John Roberts. I'm not sure about them. But I do think we do have 6 to uphold the Mississippi case. So, like I said earlier in the beginning, we won't know until June or July what the court's going to do. So we've got a 6-month waiting period, waiting for this decision to come down. With that, I'll let you go. I'll see you next time.